So the relationship between the court basically in this particular instance took into account whether the shape attained by the Lego bricks uh, resulted in some kind of a technical function, and it was found by the court that the shape attained by the brick was largely performing a technical function which can actually be protected under a different intellectual property regime and not under the trademark regime as such. So if you look at the trends in Philips versus Remington, Lego versus mega brands, it is very clear. If a shape is performing a technical function, it will not be granted trademark protection. If a shape is actually taking a natural shape of the good, then it will not be granted a shape mark. Further, if the shape is largely providing some kind of a substantial value to the goods, then that will also not be granted a shape mark as such. So with that, we actually conclude the discussion on non-conventional trademark. Now we come to the discussion on domain name. What exactly is a domain name? I'm sure most of you would actually kind of use and surf internet. And I'm sure one of the ways of actually going to a particular website is to actually type its address. Now this is usually called as the domain name system, right? So a domain name system has a numerical number which is usually called as the internet protocol number, which is usually the numeric address. And then there is also a human readable address, which is like, for instance, if we type in www.gov.in, that is usually a website where human beings can actually kind of type in numerical letters to enter a particular website. Now, who registers these domain names? It is usually done by a non-profit organization called the Internet Corporation for Assigned Names and Numbers. Now, in a number of countries, the agents of ICANN are actually present, and you can actually register your website with them. Now, when registering the websites, the ICANN actually doesn't run in whether a person who's registering the website as a legitimate business connected with the address. They are only concerned with registering the domain name. They're not considering whether a person has a legitimate business or not. So in case there is a dispute wherein two people are claiming a particular website address, then you can either go through the traditional litigation form, that is, in your own country you can start a litigation that you have a claim for a particular domain name, or you can go through the private arbitration provided under the Uniform Domain Name Dispute Resolution Policy, which the ICANN actually provides for. While domain names, it is important to keep in mind, domain names are universal registrations, but trademark protection is largely territorial. So one of the major problems with domain name registrations is the fact that there are a number of people who obtained domain names of important companies, say for instance Marks and Spencer, Coca-Cola, Sifi, Rediff, etc. While they don't necessarily own a legitimate business, they do not run anything related to those companies, they have registered the domain name, and the whole reason for registering the domain name is largely to kind of then sell it off to the original company which would ideally want that website. So cyber squatting has become a phenomenon as of now, wherein a person who doesn't own a particular business actually ends up registering the domain name in the name of a very well-known mark. For instance, taking the domain name for Marks and Spencer. And the whole idea of cyber squatters is that they are first to register the domain name, and when the company wants to register the domain name, they figure out that there is already someone who has registered the domain name. So cyber squatters would then kind of sell off the domain name to the original business at a very higher rate, right? So one of the important cases in this particular matter is Marks and Spencer's versus 1 in a million. Now this was a case where the person who had registered the domain name had absolutely no interest in the business or legitimate business connected with the domain name. The domain name registers was largely Marks and Spencer's, but they didn't actually own the domain name. The whole idea of registering was basically to ask for more money from Marks and Spencer when Marks and Spencer was ready to register a domain name. So in this particular instance, the court said that there is enough evidence for the plaintiff to show that the defendant intended to infringe the plaintiff's rights in future by registering the domain name in their name, although they did not run any legitimate business. The court here particularly said domain names largely domain name disputes can largely be resolved through disputes of trademark injunction and passing off. The court said use of a trademark in the course of the business of a professional dealer for the purpose of making domain names more valuable and extracting money from the trademark owner basically amounted to use in the course of trade. The very fact that the defendant registered the domain name Marks and Spencer without being legitimately connected with the business, and the fact that they aimed to sell the domain name at a higher rate to Marks and Spencer goes to show that the registration was in bad faith. And in all such instances, the plaintiff can readily demonstrate that there was bad faith on the part of defendant when the domain name was registered, and as such, in all such matters, the court would give instant relief to the plaintiff as such. Even in India, the domain names are treated very much like trademarks. There are cases like the Satyam Infoway versus Sifinet Solution, Yahoo versus Akash Chopra, wherein domain names were registered and the defendant largely intended to actually eat into the goodwill of the plaintiff. And as such, the courts very clearly kind of mentioned that these are instances where domain names are being registered in bad faith, and as such, passing off action was allowed. So in effect, in today's time, although domain name may not necessarily be a trademark, courts are readily intervening to treat domain names as if that they are trademarks. So with this, we actually conclude the module on non-conventional trademarks and domain name. We discussed shape marks, color marks, sound marks, and olfactory marks with respect to non-conventional trademarks, and with respect to domain names, we largely kind of discussed how domain names today have become more or less like trademarks, and courts seem to readily grant injunction and intervene when passing off or infringement actions are brought when there is cyber squatting as such. Thank you very much.